I'm trying to remember this. Mr. Fox?
Yeah, Mr. Fox.
Yes.
I can see this.
Who's supposed to be in the jail? Who's in the jail?
Foreman.
Can you stand up and move your arms?
The screen is frozen.
It's frozen. Okay, can you let the deputy know that?
What?
Okay, let's see, Mr. Goodrich.
Yes, sir.
You're here with Mr. Fox.
Yes.
On the record in the matter of the people of the state of Michigan versus Jaquan Fox, file number 24-00034, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Fox, who is appearing over Zoom today due to his illness.
Okay, Mr. Fox, today was the date that was set for preliminary examination in this matter. We were arraigned back on January 24th, and so this is the original date that was set for your exam. And so I needed you to log in because I need to address the timeline. Let's see here. You have the right to have a preliminary examination within 21 days of the date that you're arraigned. But due to you're not appearing today because of your illness, are you willing to waive the 21-day timeline so I can reset this?
Yes, ma'am.
Anybody foreseen or threatening you to do that?
No, ma'am.
Okay, you'll get a new date in the mail because I think we're having an issue with the system right now. So we'll make sure your attorney and you are advised of the next court date. Has your address changed since the date of your arraignment?
No, ma'am.
Okay, you'll get a notice in the mail. You're all set for today.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you. Just that there so that we know that it needs to be said. Ms. Swansea, is that Mr. Childress with you?
Yes, sir.
On the record in the matter of the people of the state of Michigan versus Troy Todd Childress, file number 23-03556, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. My name is Mr. Shafas, who's sitting at the council.
Okay, today's the date and the time that was set for a preliminary examination. How are we proceeding on this?
Your Honor, it's my understanding that Mr. Childress was accepted into mental health court. So I believe he'll be waiving up to the circuit court today. And people would also waive the preliminary examination and ask the case be bound over.
That's correct, Your Honor. It's my understanding also that the case has to be bound over to Judge King.
Okay. Okay, Mr. Childress, you understand your right to have a preliminary examination in the district court? The purpose of that examination is to require the prosecution to meet their burden of establishing that they have probable cause that a crime was committed and sufficient probable cause to charge you with the crime. You understand that?
Yes, ma'am.
You're willing to unconditionally waive your examination today?
Yes, ma'am.
Okay, and that's because you're going to be accepted into the, or you've been accepted into the mental health court?
Yes, ma'am.
Okay, is anybody threatening you to get you to waive your exam?
No, ma'am.
Has there been any promises made to you in exchange for you waiving your exam?
No.
So you're waiving it freely and voluntarily?
Yes, ma'am.
I understand that you can't change your mind. Once you get there, you can't decide, you know what, I don't want to do mental health court anymore. I want my exam. You recognize that?
Yes, ma'am.
Okay. Does Mr. Goodrich know, why is Mr. Trevino on Zoom? Mr. Trevino, can you remove your hat? And why are you not in person? You're muted. Why are you not here in person?
Well, I got a piece of paper stating that I'm in Zoom.
You got a piece of paper stating that you're on Zoom?
Correct.
Those are Zoom instructions. Where's your notice to appear?
Right here, my preliminary exam. The 9th at 9:30. Yeah, I got it right.
Correct. Correct. Then notice to appear. Where does it say you're supposed to be for your preliminary examination? Go up
In
to the
person.
top where it says you are directed to appear at.
It says in person, yes.
Correct. Where are you not in person?
I apologize. I misread that.
Oh, okay.
Instruction.
Well, you better hurry up and get here.
I'll be there in a minute.
Thank you. Okay. All right. Find your waiver to be freely and voluntarily given. I'll bind the matter over for a bind over date of February 21st. So February 21st is the date the circuit court's going to get the file from the district court, okay? Okay,
Yes, ma'am.
you do not need to appear in circuit court on that day. Do you have any questions?
No.
The bond was set at $7,500, 10%. That will continue. Any additional matters for the record?
You know, I would like to address,
Yes.
it is my understanding, from the mental health court that he needs to be out to fully participate to the program. And so my client has already started with the participation. He's going to CAT at the jail. This is his fifth week. He goes to A readings and he has his prescription medication and that he's taking faithfully. And so the plan is for him to, when he's released from jail, to contact CMH and start the process, continue the process. So we will respectfully ask the court to allow him to bond over, to be bond out on a PR bond.
Counsel.
So I did see that email that Ms. Wanji had just shown me. However, okay. And that email does say that they don't accept people in jail. However, from what I am aware of, I wasn't aware of any court rule or any policy that would require someone to not be in custody. And I know that we have accepted people from mental health court who were in jail at the time. So I'm unsure of what exactly that is, but
I don't know what the process is over at circuit court, but I'm pretty sure he's got to go over there and maybe plea before he can be in mental health court. He's not done that yet.
No, really, what the understanding is that he is going to be doing that and that.
Yeah, well, then they can address his bond after he enters the plea. There's no plea yet. I'm not moving the bond. You can adjust bond at circuit court, okay? Thank you. Any additional matters for the record?
Nothing for the people, Your Honor.
You're all set. Okay, maybe they. Okay, who's in the jail?
Mr. Foreman.
Okay, there we go. Who is it, Mr. Foreman?
Yes, Your Honor.
Okay, thank you. So I can remove the other one. Okay. Oh, no, they removed him. He's not there anymore. Wonderful. Okay,
These little chairs here.
are you filling in for Mr. Freeman for Foreman?
Yes, Your Honor.
Okay, maybe they'll put him right back on. Appears he has a little bit of an attitude today. Let's see here. Maynard is in custody, I believe.
And I believe he wasn't written over.
Oh,
from
he
Cook
wasn't
County.
read it. I think he did tell me that. Oh, wonderful. That one scheduled, and then we need to reset Maynard. He's already waived the timeline.
Two files, ma'am? For no one filed with a 53 violation?
Yes,
April 4th at 8:30.
April 4th at 8:30.
What is it?
Did you get that date, Ms. Wanji? For Maynard? It's gonna be April 4th at 8:30.
Thank you.
No problem. Okay, on the record in the matter of the people of the state of Michigan versus Frank Schmidt, file number 23-02825. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Edward on behalf of Mr. Schmidt, Your Honor, present to my right.
How are you, Mr. Schmidt?
How are you? I'm good.
I'm doing well, thank you. Okay, today was the date and the time that was set for sentencing. I do have a pre-sentence report and recommendation. It was dated, prepared on February 5th, 2024. Did you get a copy of that, counsel?
Yes, Your Honor, I've had the opportunity to review with my client, no additions, corrections, or changes.
Thank you, you can make allocation.
Your Honor, I spent a lot of time thinking about this case. As a lawyer, as a parent, as a member of society. And it took me back to a time where I swore in front of one of my elderly uncles, and he smacked me so hard. This is 25 some odd years ago. And I remember, I could still feel it. This was a different generation, and I remember how upset I was, and I remember the lessons I learned. Just, it wasn't directed at him, it was just in front of him. That was a different era of discipline. There was a different era of child rearing. This isn't, that's what the memory triggered for me, to think about what parents did differently and what kids did. This case presents to the court as if my client just beat up his son. And that's not the situation. Well, the situation is this child, mind you, 14, 15 years old, came into his custody because he was constantly beating up his mother and stepfather. He came over to Frank in hopes to help raise this child, keep him out of trouble, keep him in school.
I don't know what the feedback was. Continue.
And it was with good intentions. That developed into some significant challenges. Oh, that's my voice. I didn't realize my voice sounds that rough. I'm like, wow, I sound like
You're
that?
giving back feedback, but it might be whatever's going on, the jail polycom could probably do that.
I'm just worried that my voice isn't as beautiful as I thought it was.
Well, I have heard that we sound different to ourselves than we sound to others.
I have the voice of an angel at church. You should hear me
Oh,
sing.
no,
I'm like, woo.
I doubt that.
I'll put on a tune after the record,
Okay.
Your Honor, because I like to sing. But it brings us to this young man came into Frank's world with good intentions. He developed into a difficult situation. Since then, where has it gone? CPS is involved. There's jurisdiction. Frank has foregone his parental rights to Jordan, so he's not going to see him, not going to interact with him. He has 3 other children that are working through the family law courts with Judge Koenig. They have ordered paths. They have ordered rehabilitative services. The goal is reunification. In fact, they have been reunificated with the younger children in that he's able to go to the house from like 7 a.m. to 11 p.m. In all, I've spoken, he has 3 other children, 2 other women that are parents to those children that speak highly of him, that look at him as a positive role model. He has a significant history, and I can see the court looking at his history. And you know what? He went to prison as a young kid who didn't have the structure in life and was trying to save his son from the same decisions. He came back rehabilitated. His family that contacted me to represent him were confident in that rehabilitation, maintains a full-time employment. Dan Henry has a home life, a happy structure, and is in all other aspects a good man. And he's done what we expected him as they come back. I understand his record is not.
I don't see anything since 2013.
Yeah. And because he's really taken, I think, the appropriate approach. He was really distraught to find himself back in the system. I don't think you're going to see him back in the system. So I guess the goal is for us to let the family court take the rehabilitative services. They're providing those rehabilitative services. Speaking with Ms. Shanika Walker, who's the attorney in that case in our office, she's indicated that it's going to be a longer process. So we're looking more than the 6 months. And I think that's really the focus here on sentencing. And I'd ask the court to consider a finding costs in this case, allow the family law court to maintain their jurisdiction, their rehabilitative goals, and inevitably send him on his way.
And did your client at all want to make his own statement?
He did, Your Honor. Be brief.
You know, I'm a good father. I love all my children. Very remorseful, sad to be here. Pray for my son, oldest son, every day. Appreciate anything.
Counsel?
Thank you, Your Honor. I know the agreement in this case was for no upfront jail, which I'm not going to dispute that in any way. However, I do believe that some term of probation would be appropriate in this case. I'm very happy to hear that Mr. Schmidt is undertaking some rehabilitation. But I think that it'd be most appropriate for that to be through probation services. This was more than just a situation where a child was out of hand and a parent slapped them. I mean, he wrapped his hands around the child's neck and body slammed him onto the ground. This is not just a simple case. This is not just a parental discipline. I think that if that is the conduct of Mr. Schmidt, then more serious rehabilitation needs to be undertaken, and I think probation would be most appropriate for that.
Debating on whether or not to reply because I had a judge tell me one time, Mr. Zaney, shut up, you talk too much. We obviously dispute the allegations in the police report, and we ended up here on a 93-day misdemeanor for a reason. And there's a lot to it. I'd ask the court to consider its experience and what you think is best suited, and we will oblige in all ways.
And my understanding, at least from the PSI, is that he's already enrolled in anger management and parenting classes, and that's being supervised through the family court.
Yes, Your Honor, Judge Koenig.
What other resources do you think that probation could provide?
I mean, more than anything, I think it's there's sort of the if family court is sort of the carrot of things, then the probation is more of a stick in this case. And that if he weren't to be complying with those, there would be potential consequences.
I think there's consequences even if he doesn't follow the family court. And I think those consequences are far more damaging, I would imagine, than him going to jail for violating probation. I would imagine as a father, if you want to have a relationship with your children, you would want to follow the family court. Otherwise, that could prevent you from being able to have a relationship from your children. Like, that's a serious consequence. Even if I put him on probation, the programming would be for him to follow the family court order. So now I'm tying up another court process to hold that over his head. When I look at his criminal history, I don't see any interaction with the criminal justice system since 2013, which he's served that time and paid his debt on that to society. And then in addition, I understand the facts that, or the statements that you're making from the police report. However, those were not the facts that were presented for the factual basis. And so his perception and your perception don't quite align, and we're not here for what he's originally charged for anymore. We're here for an assault and battery, which he admitted to assaulting, obviously, his child. I don't know what the circumstances were. I wasn't there. I do know that we're dealing with, we're talking about a 14-year-old child. Is that correct? It's interesting because recently I had to go, sometimes I go and I read to students or I meet with students, and I was recently visiting a local school, a high school. And I was sharing with family and my staff how scary of a situation it was being in that high school with people in the age range of 14 to 18. I witnessed more than 2 fights in the hallway while I'm walking through the hallway. We're not dealing, and not to ever excuse any behavior that's inappropriate when it comes to how to discipline. But I think that it's a scary situation dealing with unruly teenagers. And it could be provoking. It could cause you to make decisions that are poor and not justifiable, although understandable. And so I think that the course that you're on at this point, which is you're getting some anger management, you're getting some parenting tools, could help you hopefully make better decisions as to how you interact and how you discipline your child, because that's your job as a father. You have to be able to discipline your children. If you don't discipline your children, then guess who's going to have to discipline them? The court. I was raised in the church. My mother is a minister. You spare the rod, you spare the child, is what I was taught. The law has came in and intervened and changed that. And so you no longer can apply the rod to discipline your child. I'm not a legislator. I don't make those laws, but I do work in the public sector, as do both of you all. I mean, you're a private attorney, but obviously you deal with crime. And you can see where we're trending. And a lot of that could be abated if we had better parenting, or a parenting that was more disciplinary. Not to say that you should be grabbing your child around the neck or slamming them or hitting them with rods. That doesn't mean that, I don't believe that that's the best way to address a child, but I think that there needs to be more stern and intentional discipline. And parents need to feel empowered to some extent as to how to do that. And I think he's getting those tools now about what's the best appropriate and legal way to be empowered to discipline and redirect your child, and not allow the actions of a teenager to provoke you to such anger that you find yourself before the court. Because in that case, the child won and not you. And so I was going to place you on term of probation regardless, because as indicated by the prosecutor, I think that it's important to keep some oversight to make sure those things happen. But my intention was always to place you on non-reporting probation. I don't think that reporting here and making drops are going to assist you and rehabilitate you as it relates to this. I think you're already doing those things, but the court is going to maintain some oversight to the extent that we will place you on a term of 6 months non-reporting probation. While on probation, the order of the court is for you to follow all orders of the family court and CPS orders, and to continue your anger management and parenting classes. You'll provide evidence of the anger management and parenting classes to our probation department. You will not otherwise be required to report to our probation. Do you understand that?
Yes, ma'am.
As to fines and costs, there's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that must be assessed. I'm also gonna assess a fine of $250 when you make payment on your fines and costs.
Hey, some today,
How much you gonna pay today, sir?
maybe 175.
Okay, so that'll leave a balance of $200. When are you gonna pay that?
Probably pay it. It's all the money I have on.
I'm not asking you to give us all your money right now.
No,
I just wanted, I just need to put in the file what date you intend to do that.
Next week.
Okay, so that we can
Next
follow
week,
that,
right.
okay. Okay, I'll note that you'll make a payment today and then you'll pay the balance by next week, is that what you're saying?
Yes, ma'am.
Okay, you're also go downstairs to probation. Once you leave here, they'll get some information from you. And then, again, you'll provide them evidence that you have been following the CPS order and that you have been participating in anger management and your parenting classes, okay?
Yes, ma'am.
Any additional matters for the record?
Nothing for the people, Your Honor.
Nothing from the bench. Thank you for your time today.
Actually, there's an additional matter. The advice of rights. As to Mr. Zaney, yes. Your client has the right to request early discharge from probation under certain circumstances. Once he completes half the original term ordered by the judge. That document, you need to read it because you gotta give it back to me. It tells you what circumstances allows you to request early discharge. No, he has to read it. I need to put that in the file.
Oh, okay, you want an initial, it's not into the station. Sure.
I'm not sure. Do you still have a GPS tether on?
Because you're,
I do
Okay.
not.
you don't? You do not?
I was
I've
gonna
had
say, you
taken
should-
off for a long
okay.
time.
Okay, well, excuse me. Friday, I apologize.
He should have had it taken off, I believe.
Yeah, I think we addressed it last time.
Okay, and so again, unless you were on probation for domestic violence, CSC, stalking, or an offense where the defense of guilty but mentally ill was asserted, you are eligible for a request for early discharge. So if you get all that paperwork verification to our probation department within the next 90 days, you can request early discharge from probation, okay?
Thank you very much.
Okay, any additional matters for the record?
Nothing for the people.
You're all set. Yes,
I will tell the court I'm a little disappointed, Judge.
why is that?
Mr. Stevens saw my green suit. I dressed with this color. I said, Judge is gonna appreciate my color tone today. And only Mr. Stevens noticed it.
Oh,
So I'm just
okay. I was
saying,
like-
I'm just saying, I dressed up.
I
This
did
is
notice
gonna
it.
end.
You give me an opportunity.
Oh, my
You even
bad.
got a pink and green.
And my
I
wife
see
said
what
that's okay.
I see what you did.
See what I did there?
Well, you know I'm an AKA, so I always approve of pink and green.
I appreciate that. I remember that. I just, I put it on just because I said, battle of color. Sometimes we know we like to dress
I'm
up.
gonna take back all those nice things I said.
That's okay.
With
I'll
that,
get
with
one.
that sinful lying about a songbird.
Thank
so-
you. A sound of an angel.
I know,
Oh,
right?
I am. Oh,
Don't
I
make- Don't make lightning come down in my
Yeah.
courtroom.
I'm gonna sit in church next time, trying to listen to really how I sound. No
You
wonder my
could
kids
try
listen.
that around. Remington doesn't know you that well. He could probably
Oh,
believe that.
oh.
Oh,
boy.
no.
I thought-
No, no, nobody asked for that.
No, but yeah, you're ready for it. I appreciate it.
Have a good one.
Take care, Your Honor. We can
Okay.
smile and be happy on the way out after
Mercy.
seeing that day. I think we're good. Bye.
Wait, isn't that what I said when after I made that bacon fry yesterday? Well, we made you cry today. I think
Yeah,
we're
I think we're
gonna
good.
have
Yeah,
here.
we're good that here today.
He wants to leave happy, I leave, then everybody crying.
Oh, that goes.
It was like so
He said he's on his way now.
Yeah, I was just informed that. Thank you.
Okay. No problem.
Glad someone can get hold.
No worries. On the record in the matter of the people of the state of Michigan versus Jaquan J. Shaw Foreman, file number 24-00140, council appearance.
Judge, he actually has two.
I
dockets.
see that now, actually. Let's see.
Yeah. Other-
I also have, let's see, city of Lansing case. Is that-
There's a 24-140 FY and a
Oh, okay.
23-3603
I also
FY.
see people of the state of Michigan versus Jaquan Foreman, file number 23-03603. Then I also have people of the city of Lansing versus Jaquan Foreman, 23L2804641. Council appearance.
Andrew Stevens on behalf of the people and the two FY files.
Thank you.
Good morning, Your Honor. Attorney John Abbott with the Public Defender's Office, standing in temporarily for Mr. Freeman, who is unavailable today.
Okay, today was the date and the time on both matters that was set for preliminary examination. And Mr. Freeman's not here. How are we proceeding?
Your Honor, just as by way of a little backdrop, and I provided Mr. Abbott the email exchanges that I've had. I actually sent it to Ms. Nash, and I'm learning as I appear today, and I don't know that Ms. Nash was present today. I didn't send it to Your Honor, but at the probable cause conference for the 24-140 FY file, Mr. Freeman and I discussed timing. Both parties indicated that we were going to proceed with and be prepared for the preliminary examination today. The only caveat to that was that Mr. Freeman was beginning a trial in 30th Circuit before Judge Jamo on Monday. That trial started. Unfortunately, and I would add that at the probable cause conference, Mr. Freeman indicated that he did not believe that that trial would be any issue with today's preliminary examination. Unfortunately, on day 2 of trial, Judge Jamo called in sick and only appeared for half of a day on Tuesday. He does not hold trials on Wednesday and only holds half of the trial on Thursday. And so as a result, they were behind schedule. And as I understand it from Mr. Freeman and the prosecutor handling that matter, they intend to finish today, but of course that means that Mr. Freeman cannot be present today. Mr. Freeman informed me of all of this on Wednesday. I told him that I would notify the court, as I had indicated a moment ago. I told Ms. Nash, and that I would also cancel my subpoenas, of which Mr. Freeman was in agreement. I emailed Ms. Nash yesterday, and then Mr. Freeman followed up indicating that everything that I said in the email, which is what I've repeated here today, was accurate. Again, I've let Mr. Abbott review all of that email, so you can sort of confirm what I'm indicating today. Consequently, what that means, whether Mr. Foreman was going to waive his 21 days or timeline, I think is a largely irrelevant fact. And pursuant to the statute, this court can find good cause, and I think the circumstances certainly warrant that. And so as a result, this matter, which was scheduled for today, should be adjourned.
Okay, very good. And Mr. Abbott, you're just here for the purposes of waiving the timeline, is that correct?
Well, yes, Your Honor, I asked the court to find good cause. His, what he just said is confirmed by what I understand to be true regarding the length of trial and Mr. Freeman's unavailability due to him still being in trial in Judge Chamber.
Okay, so for your information, Mr. Foreman, hopefully you heard everything that was stated here by the prosecutor. Your attorney is tied up on another trial and not able to be here today. And so you have 2 matters, and one of which we need to address the timeline. In the file number 24-00140 FY, which you're charged in count 1, homicide, open murder, count 2, assault with intent to murder, count 3, weapons, firearm discharge from vehicle causing death, count 4, weapons carrying concealed, count 5 and 6, weapons, felony, firearm. And I see an habitual offender second offense notice. That matter you were arraigned on January 22nd, 2024. You have the right to have a preliminary examination within 21 days of the date of that arraignment date. However, due to your attorney's not being available because he's tied up on another matter in trial, the court's gonna find good cause to go beyond the 21 days and reset this matter for a new trial date, okay? I'm sorry, a new preliminary examination date, okay?
Okay.
How long do you need for an exam? Do you need a full day or?
I'd say probably half day. I don't think it's a full day.
We can put it on a day, we'll probably have PCCs maybe.
Judge, I would just indicate, I am scheduled to start a homicide trial with Judge Aquilina on February 23rd.
Oh, we're not scheduling to February anymore, we're in April.
I'm just, and it would go 2 weeks, but if you're talking April, then I don't think I have an issue with that.
April 4th at 9 a.m.
April 4th at 9 a.m. work?
You want both files scheduled at that time?
Yes, please.
4/24 at 8:30.
4/24 at 8:30.
I don't have anything on my schedule.
Oh, I'm sorry, at 9.
That
It'll be at
appears
9.
to be an issue, so that is fine, Judge. Thank you.
Okay, we'll set both of those matters for that purpose. Why did they give me this city attorney
There's
file?
a warrant on that one, ma'am. Are you finding good cause on both files?
The other one, the timeline was already waived.
Okay.
It was arraigned on that December 1st, it looks like. Let's see. So I'll reset to 4/4/24 at 9 a.m. They gave me the city file. I don't know why he would.
I believe he has a warrant on that from Andy's notes, ma'am.
No offer reset to work out plea is what I see. He didn't appear on the 5th, but he's obviously in custody, so quash warrant. Defendant in custody. So we'll get him properly rated on the city file. And we'll reset that one.
He's going to accept the plea offered and use of that.
Okay, cool, then I will fill out the sheet.
We have a new date for the city file.
I believe it's file, I would be on that. Monday, February 22nd.
At what time?
10 a.m.
Okay, and Mr. Foreman, you have a failure to display ops with the city of Lansing. And that's gonna be reset for February 22nd at 10 a.m. We'll make sure that there is a notice provided to the jail so that you could be put on, okay?
Okay.
Okay, do you have any questions for the court today?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you, Your Honor.
Thank you. Bethany Christian Services? Who's that? Who's Bethany Christian Services? Or they removed themselves, so I guess they don't want to be here anymore. Mr. Abbott, you have Mr. Jackson here?
Yes, Your Honor, Mr. Jackson's in the hall.
Okay, and you have Mr. Trevino?
Yes.
Are we running Trevino?
Trevino's gonna be a plea.
Okay, are we ready on the plea?
I'm filling out the plea sheet.
Okay.
Yeah. gonna have to, we're gonna go this afternoon, so I have to,
Because of the
yeah, so I have to figure out which time I want to back for and then. And then I'll probably let him go and then have him come back, but I
I
don't know what time yet.
will. Start to Increase those rates.
Thank you so much.
I don't think I have a file now.
The Maynard one? Yeah.
He has, yeah, it needs to be, they never rented them.
Okay, I thought we had talked about that, but
Yeah.
I was like, I never scheduled this. Maybe I'm not paying attention.
Oh, I tried right now, I'm missing some out. I just want to add that real quick. And then that's good to go.
You're gonna do an invasive rights form as well. So do that.
Thank you. Okay, on the record, in the matter of the people of the state of Michigan versus Juan Trevino Jr., file number 24-00171, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Trevino, who's standing to my right today.
Okay, Mr. Trevino, you got here rather quickly. You must not live far. Okay, very good. Today was the date and the time that was set for preliminary examination. I have a plea sheet. The people are offering for you to plead guilty to an added count 2 of use of a controlled substance, MCL 333.74042B, with no objection to sentencing under 7411. In exchange, the people will dismiss count 1. You understand that to be your plea offer? And you want to accept that offer? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. Have an advice of rights and plea information sheet. There's today's date on it. There's a signature at the bottom. Is that your signature?
Yes.
Okay, did you review this document?
Yes, I do.
You understand the rights listed there?
Yes, I do.
Do you have any questions about those rights?
No, I don't.
You can give him that copy, please. Are you willing to give up each of these rights in order to accept the plea of guilty to use of a controlled substance? Okay, you understand that you have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecutor to prove your guilt at trial. You have the right to jury trial. You have the right to remain silent at trial and not have the silence be used against you. You have the right to confront in court any of the witnesses or accusers that is called to testify against you, and you have the right to call your own witnesses to your trial or present evidence that you believe show a defense to the charge being brought against you. You have the right to require them, being the prosecutor, to prove each element of the charge being brought against you beyond a reasonable doubt. You want to give up all of those rights?
Yeah.
Anybody threatening you to do that?
No.
You sure? Any promises being made to you in exchange for a guilty plea? Are you okay?
Yeah.
Okay. Are you currently on probation or on parole?
Oh, no.
Okay. You understand that a guilty plea could result in a conviction that you may need to report to your current employer. You may need to put this conviction on a future job application. You also could have an impact on travel or immigration status that you may be seeking. Okay, you understand that you're still willing to give up your rights and plead guilty to the amended charge? As to the added count 2 abuse of a controlled substance, how do you plead? Factual basis?
Thank you, Your Honor. Your Honor, we would like to lie the factual basis for the underlying offense in this matter.
Okay.
Okay, on or about January 23rd of 2024, were you operating a motor vehicle at 540 West Willow Street?
Yes.
And is that in the city of Lansing, County of Hingham, State of Michigan? And you came in contact with police on that occasion, correct? And when you came into contact with police, were you in possession of a mixture that turned out to be cocaine?
Correct.
And you knew that it was cocaine when you were in possession of it?
Correct.
And you didn't have any prescription or any kind of legal right to possess that cocaine? Okay, Your Honor, I believe we have a factual basis for possession of a narcotic, cocaine or narcotic.
Any questions from the prosecution?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea, and I find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing
April 5th at 9 a.m.
April 5th at 9 o'clock in the morning. When you leave here, you go downstairs 1 floor to the 5th floor. You'll be escorted there so that you can meet with our probation department. They'll get you set up for your pre-sentence report, which is going to be used to make a PSI so that I can know how to best sentence you. You will be required to undergo a substance abuse assessment, okay? Do you have any questions? Okay. You can appear for your sentencing via Zoom, okay? Any additional matters for the record?
Nothing for the people, Your Honor.
No, Your Honor.
Okay, you're all set. Thank you. Okay, Mr. Abbott. Where's Mr. Jackson?
Your Honor, do you have an idea of about what time we Yes, sir.
Okay, on the record in the matter of the people of the state of Michigan versus Harry Jackson, file number 24-00148, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. John, I'm representing Harry Jackson. He is present and seated to my right.
How are you, Mr. Jackson?
Doing good.
Okay, today's the date and the time that's set for a preliminary examination. My understanding is that we're ready to proceed.
That's correct, Your Honor.
Okay, any preliminary matters before we call witnesses?
Nothing.
Sequestration of witnesses, Your Honor.
Sequestration is granted. Are they all officer witnesses?
They are, Your Honor.
Okay,
I have a witness here, Your Honor, that's going to testify. If we go to trial, she'll be a witness.
okay. What's her name?
Angela Lawson, I'm his mother.
Okay, well, his attorney's requesting sequestration, so you need to step outside, okay? Thank you. Okay, you can call your first witness.
Thank you, Your Honor. People call Officer Andrew Armstrong. Just remember the judge.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. Let's see over there. And you state your first and last name and spell both of them.
Andrew Armstrong, ANDREW, ARMSTRONG.
And have you testified in court before?
Yes,
Okay, counsel, you can proceed.
Thank you, Your Honor. Good morning, Officer Armstrong. Where do you work?
Lansing Police Department.
And what is your job title?
I'm a police officer.
What are your duties?
I work road patrol.
Were you working as a police officer on January 20th, 2024?
I was.
And how were you dressed?
Standard Lansing Police patrol uniform.
When you were working that day, were you dispatched to 3945 West Jolly Road?
Yes,
And is that in Lansing,
yes,
Ingham County?
Eaton County.
Oh, it's in Eaton County?
Yes,
To the best of your knowledge, is that within a mile of the county line with Ingham?
yes,
And is that in the state of Michigan?
yes.
Why were you dispatched then?
I was dispatched for a troublesome subject. I believe it was the initial call. And responded down there and, investigated and ended up becoming someone else.
And so you did go to that address. What did you first observe when you arrived?
I met with the victim, who I know from previous contacts. And I remember going into her apartment and it was disheveled. There was broken, a couple broken televisions, some other broken items in the house.
When you spoke, what was the victim's name?
Erica Rutledge.
And when you spoke with Ms. Rutledge, what was her demeanor?
She was, as I recall, she just seemed fed up.
And did she have any physical injuries when you spoke with her?
Yes.
Did you obtain any information about the relationship between Ms. Rutledge and Harry Jackson?
Yes.
And what was that relationship?
I recall that they had at least one child, I believe 2 children together, and they were living together on and off.
And without telling me what she said, did Ms. Rutledge describe or explain how she had received her injuries?
Yes.
And did she describe or explain why she called 911?
Yes.
And did you learn when those injuries occurred?
Yes.
When was that?
The previous day.
And did you learn where the incident occurred?
Yes.
Was it at that address?
It was in the parking lot of that address.
Okay. Your Honor, at this time, the people would seek to admit the statements from the victim to this officer pursuant to MCL 768-27C as all 5 elements have met. In particular, a statement was made about physical injury that was made at or near the time of infliction involving a domestic relationship under circumstances that would indicate trustworthiness and made to a police officer.
Thank you. Any objection?
Not objecting about the things that happened on the 19th, Your Honor. But as to anything that might have happened on the 20th or 21st, Your Honor, since the alleged assault behavior happened on the 19th, that I don't think any testimony regarding what might have happened, any hearsay that might have been attempted to be admitted regarding what happened on the 20th would be inadmissible, since it's not part of the thing that happened on the 19th.
I'm a little confused. He's narrating or going to narrate an incident that he took a report on, I believe, on the 20th. And you're objecting to him telling you about what happened
On the 20th, because 768-27C allows hearsay testimony for domestic assault, domestic violence,
Okay,
but that happened on the 19th.
so to the extent that none happened on the 20th, you're saying you object to that hearsay coming. If the court finds that whatever information is provided about the 20th is not related to that incident, because sometimes it could be a continuous action, then the court knows how to throw that evidence out.
Thank you.
So your objection is noted. Thank you. Thank you, Your Honor.
So what did Ms. Rutledge say happened
From the 19th to the 20th.
from the 19th?
Okay. That they've been arguing, as I recall, they were arguing and they're out in the car and her child's father, Harry Jackson, punched her multiple times in the legs and buttocks, and it caused bruising.
Did she describe any other incidents that occurred with Mr. Jackson?
I'm familiar with this person. She's called 911 a number of times in the past. I believe Harry's been arrested at least one other time by LPD for domestics, but generally we have an uncooperative victim that I know of common with domestic violence assaults.
So when she spoke with you, why did she call 911 that day?
So her and Harry got into a verbal argument, verbal fight, and then she was trying to call for help, but he had her phone, as I recall.
Objection, Your Honor. Well, I'm sorry. I'll hold off.
Okay. Continue.
And then again, as I recall, he at one point smashed.
Now we're in the hearsay that isn't part of the punching in the leg that happened on the 19th. We're now talking about a separate event the next day. I don't think this is admissible.
Okay, I was gonna ask, because I don't think he made it clear what day this was. What day was this?
The time, are we talking about the 20th or the 19th?
Well, the incident you're talking about now with the phone.
That occurred on the 20th.
Okay, you're objecting as it being inadmissible hearsay?
Yes, Your Honor. The officer testified that it was a verbal argument, and then he started to describe some property damage. It's not connected to the assaultive behavior that happened the day before. It's not part of that event.
Counsel?
Your Honor, the defendant in this case is not just charged for the conduct that occurred on the 19th. He's also the felony in this case, the felony that I need to prove the elements of. That felony occurred on the 20th. So it was part of an ongoing domestic incident. So I don't understand how the statute wouldn't apply to hearsay from this incident.
So you're saying that the domestic violence incident started on the 19th, continued into this point? Is that what you're saying?
Yes, Your Honor.
Okay.
And also on the complaint, the date is of the interfering with the electronic communication. It is listed as taking place on the 20th.
I recognize he's objecting to that, there being hearsay as to that. I need some information from your witness. He was testifying, he shared that the defendant, and I'm noting your objection, but I don't know that it's appropriate yet because I don't know. I need to know when was the phone taken from this alleged victim. He said that
I
Mr.
believe the
Jackson
phone was
had the
taken
phone.
on the 20th.
You believe it was taken on the
From
20th?
my recollection.
Okay. How are we connecting the 19th to the 20th as a one continuous incident?
I would, well, I would say that they, given the closeness in time and the continued ongoing threat of violence, the conduct by the defendant, which we haven't fully gotten into, on the 20th, all of that is still either threatening or inflicting physical harm on the victim, who is in a domestic relationship, in a domestic situation.
Okay, so you want to add to your objection?
There hasn't been any testimony that there was an ongoing threat or any ongoing.
I was gonna say, maybe we're gonna get there. That's what I was gonna say. So I'll hold your objection in abeyance. I'll allow her to continue with eliciting testimony from her witness, and then I'll make a ruling on the objection.
Thank you, Your Honor. So when, sorry, I need my place again here. So, speaking specifically about the 20th, when Miss Rutledge went to try and call someone, did she tell you why she was doing that?
She, as I recall, she was trying to call family for help.
Why did she need help?
From my recollection, she felt she was going to be assaulted.
And why did she feel that way?
Just because of the accused in this situation smashed the television with a hammer, and then had access to her phone, so she wasn't able to call anybody, and then smashed another communication device. I believe it was like an iPad or a tablet of some type. And she ended up running out of the apartment and banging on a neighbor's door until someone opened up and called 911 for her.
When Mr. Jackson was hitting things with a hammer, did she say where she was or if there's anyone else in the room?
Yeah, so it was in the main living room area of the apartment, and there was also there was a 1-year-old child in close proximity of that television.
Okay, so did she have concerns for safety?
Yes.
And you had said she believed she was going to be assaulted?
Is that a yes?
Yes, sorry, Anna.
And then when she went to call for help, if you could just detail what happened then.
So, yeah, as I recall, she was going to grab a tablet and contact family through Facebook or similar social media. And then the accused broke that, so she couldn't call anyone, communicate with anybody. And then she went and she left the apartment and started knocking on her neighbor's doors, and someone opened up, and I don't recall if she used their phone or if they called 911 for her, but at some point the police were contacted.
Okay, I need to go back just to get some clarification here. So your testimony is that she reported to you that on the 20th, she was engaged in some kind of verbal altercation?
Yes.
Okay. Did she indicate to you, had he touched her at all?
No.
Okay. But that he had caused some damage to some property?
Yes.
Using a hammer?
Yes.
Did she give you any indication that she felt threatened that she was going to be harmed?
From what I recall, what she said was that she just wanted it to stop and wanted him to leave.
She wanted it the interaction to stop.
Yeah, the interaction, the fighting to stop.
Okay. And then he had smashed the TV, and what else did he damage?
It was an electronic tablet.
Okay. You can proceed.
Your Honor, when you spoke with Ms. Rutledge, did she give a physical description of the defendant?
Not off the top of my head, I don't remember.
Okay. And was the defendant there when you had arrived?
No.
Did she advise where he was going?
No,
When defendant was destroying the belongings with a hammer, did she say how close she was to him?
not that I recall.
Was she in the same room?
Yeah.
No further questions.
I just thought, you said she did not give a physical description?
Not that I recall.
Okay, but were you testify you were already familiar with Mr. Jackson?
Yes.
Okay. So do you believe that's why you didn't get a description?
Yeah.
Okay.
And
She
she'd
gave
given-
you his name?
Yeah, so she'd given his name, his age, and just due to call history, we'd already had his information before we
Okay.
arrived on scene.
Okay, cross-examination.
But you'd never met him before?
No. Interacted with, never shook hands or anything like that.
Okay. And you didn't write anything in your police report about how she felt threatened?
Not that I recall.
And you didn't write any. And by threatened, I mean threatened on the 20th, that day when you talked to her?
Not that I recall.
Okay, thank you.
Any redirect of this witness?
No, Your Honor.
Okay, as to the objection as to hearsay being admissible under 768.27C for the purposes of the count 1 interfering with electronic communications. The testimony of this witness was that there was an altercation or a verbal altercation that ensued that led to the defendant or the person alleged to have been the defendant smashing a hammer into a TV, into another device, and that the defendant supposedly had the victim's cell phone as she was trying to make communication for some help. And then her having to retreat, allegedly to use someone else's phone to contact law enforcement. The court, I don't believe, I don't have enough information to tie this as one continuous event, but I do believe that based on the circumstances and the history that the incidents on the 20th do purport to narrate a domestic event, and that she had reasonable, if true, it was reasonable for this particular person to have believed that she would have been assaulted if this is a situation based on the testimony where she's called law enforcement multiple times due to being assaulted. And when the officers arrived on that date, she's got injuries from allegedly being assaulted the day before. So the objection is overruled. This witness can be excused. There's a sequestration order, so you can't talk about your testimony with any other witness, okay?
Yes, Your Honor.
Thank you. You're free to go. You're next.
Thank you. The people call Officer Mark Fox.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat. And Officer Mark Fox, is that the common spelling?
M-A-R-C?
M-A-R-C, okay. F-O-X.
Yes, ma'am.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Officer Fox. Where do you work?
Lansing Police Department.
And what's your job title?
I'm a police officer.
Were you working as a police officer on January 21st, 2024?
Yes, I was.
And were you excuse me, were you dispatched for a troublesome subject on that day?
Yes, I was.
Can you describe what occurred?
Dispatch stated that there was a domestic violence incident that was active, and I was dispatched to the area.
Okay. And did you go to the address or where were you?
Before, I didn't get a chance to get to the address. Dispatch advised the accused vehicle, and I spotted the vehicle prior to arriving at the address and made a traffic stop on that vehicle.
Okay. Did you, so you made the traffic stop on the vehicle?
Correct.
And the vehicle matched the description you were given by
It did.
dispatch? Did you speak with the driver of the vehicle?
I did.
And what was his name?
Harry Lewis Jackson III.
And did you see his face?
I did see his face.
Would you recognize him if you saw him today?
I would.
Is he present in the courtroom?
Yes, he is. The defendant.
Okay, just for the record's sake, could you just describe where he's sitting in a piece of clothing?
He's sitting next to his attorney. He's wearing a red, blue, and white jacket.
Thank you. For the record, or let the record reflect that Officer Fox has identified the defendant.
Any objection to identification?
Nope.
Identification is noted.
Thank you. Did you speak with him?
I did.
And I should ask, did you place him under arrest?
We detained him at that point in time, and I did speak with him seated in my patrol vehicle.
Okay. After he was detained, did you read him his Miranda rights?
I read him his advice rights off of the card issued by Lansing Police Department.
Okay. And did he waive those rights?
Yeah, he wished to speak with me.
Did he make any statements about his relationship to the victim in this case?
He stated that he was at the victim's residence on 1/9/2024, and that they had a verbal altercation, and that he broke a TV and she broke an iPad.
Thank you. No further questions.
Cross-examination.
No, thank you.
Okay. May this witness be excused.
I just had one more question that I forgot to ask. What was the victim's name?
I don't recall.
Thank you. No further questions.
Thank you, Officer Fox. There's a sequestration order, so you're not allowed to discuss any portion of your testimony with any other witness, okay?
Yes, ma'am.
Thank you. The people have any other witness or evidence?
No, Your Honor.
Are you calling any witnesses?
Not today, Your Honor.
Okay, argument?
Thank you, Your Honor. I know you've got places to be, so I will just rely on the evidence presented today and ask the court to bind this case up over as charged. Thank you.
Renew my objection to the admissibility of the evidence regarding the destruction of property, although I heard you. As far as identification goes, however, the officer testified that pulled this person over, and this person admitted to being in an argument on the 9th of January. So his testimony was. So there's really nothing that links this particular individual with the assault that happened on the 19th, or on the alleged property damage that happened on the 20th, or the alleged interfering with an ongoing phone call. Also, Your Honor, I'm not sure there's no testimony that she was making a phone call. She was, the phone was in his possession, and that the laptop she might have used in the future, or the tablet, was damaged, smashed. So that there was no actual testimony that there was an ongoing phone call, and there was no testimony by anybody that this is the guy that was there at that time.
My understanding is there was a tablet and a phone.
Tablet and a phone.
Okay, that the tablet was smashed, not the phone.
Tablet was smashed and the phone was in his possession.
Okay. Thank you. Any re-argument?
I would just briefly say that the The requirements from the jury instructions in the statute only require that the defendant prevent, obstruct, or delay by any means the sending of an authorized communication through a telephone line or any electronic medium, including like internet or computer. I believe there was testimony from Officer Armstrong that when Ms. Rutledge said that she was going to call for help, that was when defendant took her phone away, which would be in a delaying of her ability to get help via the phone communication. And then also, in addition to that, when she tried to get some sort of help via Facebook or the internet or some sort of means through her family, then the defendant also smashed that tablet. So that would be another instance of the defendant preventing, obstructing, or delaying the sending of the communication.
Okay, thank you. Today was the date set for a preliminary examination, and the burden is on the prosecution to establish that they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. This is not a trial. They don't have to prove each element beyond a reasonable doubt. They just need to provide the court with more than mere suspicion that the crimes alleged occurred. And that testimony can be, or that evidence can be satisfied by testimony. And in this particular case, if the court makes a ruling that hearsay is appropriate under NCL 768.27C, then hearsay can be admissible to narrate those facts. We had testimony today first from Officer Andrew Armstrong. He testified that on the date of January 20th, 2024, he reported to the address of 3945 West Jolly, City of Lansing, Eaton County, within the 1 mile radius of Ingham County, and he was dispatched for a troublesome subject. He stated he met with the victim, who he was familiar with it from previous contact. He identified by name the victim, Erica Rutledge, I believe he said her name was. He described her demeanor to be fed up, is what he said. Not really sure what fed up means, but that could mean a lot of things. He did note that there were visible injuries and that she indicated that she had at least one child, maybe 2 children together with the person that she accused of assaulting her, that being a Harry Lewis Jackson. Officers stated that he did not receive a description or a physical description, but that he was already familiar with the defendant from previous contacts, but that the name and date of birth was provided during this particular interaction, that the victim reported that she and the accused were allegedly living together on and off. The injuries, again, occurred from the previous day incident that occurred in the parking lot at that address. And the report indicated that on the 19th of January, the victim and the accused were arguing in the car, and it led to the accused punching the victim multiple times in the legs and buttocks. The officer then testified about an incident that had occurred on the 20th, just prior to the police being dispatched to that address. On the 20th, the victim alleges that she was trying to call her family for some help, and that the defendant or the accused had her cell phone, preventing her from using it, that they had been in a verbal altercation, and that he had used his hammer to smash the television. A tablet was smashed during this altercation, and that she retreated from the apartment to a neighboring apartment to call 911 for assistance. There was an objection as to whether or not the incidents narrated for January 20th fell under 768.27C. The courts made a determination that that does fall under 27C, as it does purport to narrate, describe, or explain the affliction or the threat of a physical injury upon a declarant. And the court made the interpretation based on the fact that This is a situation that occurred a day after she allegedly had been assaulted. Bruises still on her body from the day before. Another altercation takes place, and she is allegedly in the home with someone swinging a hammer, damaging property, including a device that she can use to call the police. A reasonable person in that situation would feel threatened for physical harm. So the court determined that the incidents narrated for the 20th will come in for appropriate hearsay under 27C. The officer Fox testified that he was dispatched on the 20th to the address stated again 3945 West Jolly, that he was dispatched due to a report of an active domestic situation, that the dispatch provided a description of the vehicle of the accused. Officer made contact with that vehicle that met that description prior to getting to the address of that was provided, but in that area, he made contact with the person he identified in the court as Mr. Harry Lewis Jackson. And that Mr. Jackson provided some information about a interaction that led to some property damage at that incident. Whether or not the officer or whether or not the defendant told the officer that there was some damage done on the 9th or the 19th is unclear, if to the court at least, whether or not the defendant was telling the correct date, or maybe the defendant used the wrong date, or the subject that is, or whether the officer misspoke. What I do know is that the officer intercepted the person who fit the description of the accused in the vehicle that fit the description of the accused at the time frame in close proximity to the call for a domestic. And he ironically shares details information that would corroborate that some incident did take place. The court does believe that there's sufficient probable cause as to count 1 to bind over for interfering with electronic communications on or about January 20th at 3945 West Jolly Road. Counts 2 and counts 3 are misdemeanors. Those will accompany count 1 to the circuit court. A bind over date is going to be February 21st. That's the date the circuit court gets a file from the district court. You do not need to appear in the circuit court on that date, okay? Your next court date will be a pre-trial. Mr. Abbott will be made aware of that date. You stay in contact with him, okay? If your address changes, you need to make sure you update the court and your attorney with the new address. Do you understand that?
Yes, ma'am.
Bond was set at 10,000, 10% with GPS tether. You're not to be within 2,000 feet of the exclusion zone. Make the notification if possible, and there was third-party contact allowed regarding custody issues of the child. Do you have any questions about the bond? Okay, that bond will continue. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
Thank you. You're all set.
Do either of you want the transcript?
Yes, I could.